Hello, everybody. Wanted to talk quickly about another case that came down here in the past week. I'm calling this one Tiger King Dethroned, right? This is the case about the zoo, the Tiger Zoo here in Indiana. It was Wildlife in Need, Indeed, Inc., right? Wildlife in Need and Wildlife Indeed, Inc., known as WIN, W-I-N. And the owner of it was held liable personally for these corporate debts and corporate mismanagement. So this is really a case about that I'm reviewing on the issue of piercing the corporate veil. That was one of 3 issues the court decided. I'm not going to go into the other 2 because it's not really relevant. But this was the guys that they were featured on Netflix, the movie The Tiger King in 2020. They were also in a sequel, Tiger King 2, that was also on Netflix. Those were hit movies, so a lot of people may have seen it. And these guys operated an exotic zoo here in Indiana, and they had a not-for-profit. And apparently, the court found it after an evidentiary hearing. They found that they misappropriated a lot of funds and they violated animal rights statutes in a lot of ways. So that was sort of the case in chief. But the key thing that I want to talk about, as always, is piercing the corporate veil. Everybody always asks me these things. We've got the 7 or 8 factors in Indiana law, but the Court of Appeals made a short decision on that final issue, and I'm just going to read that part of it to you from the case where they found that there was personal liability for the owners. Okay, so one thing was that in his testimony, Mr. Stark, who was the individual named personally, testified, quote, "For the last 21 years, I am wildlife in need." So he's asserting that he is literally the alter ego of the company. That's per se, you blew it, right? If he had proper counsel or if he had better preparation, hopefully he would not have said that. Some of these proceedings were done pro se, meaning he didn't have a lawyer, but he clearly viewed himself as the organization. That's a problem. So a lot of times on business cards, I see the word owner or I see the word founder. Don't use those. Use your legal title like president or manager of an LLC. That's the most appropriate. Or some other title that's like a real corporate officer. It's not you personally. Otherwise, you're going to be found liable. So that was the first big mistake he made. Very big. The other thing he did is that the court says he routinely used WIN to pay his personal obligations. That's a no-no. He took WIN assets, commingled WIN assets with his own. When he was president, he failed to maintain proper corporate records. That's another indicator. He failed to observe the required corporate formalities. Again, those are key issues. And finally, the trial court concluded he is personally liable for the funds and assets misappropriated. So those are a lot of the key factors that we see all the time, and I wanted to bring them to your attention, especially that first one where he asserted that he was the entity. He was the business. Never do that. You're just the manager. You're just a corporate officer, right? So don't do that. That'll help keep you out of trouble. We defend your territory. Shout out again on our bumper music. I hope you're seeing this one. Zach Dowd, D-O-W-Z-Y. You can find him on Apple Music and Spotify. Hope you enjoy it. Have a great day.